My name is Mohammed Abduroaf. I'm a practicing advocate in the Western Cape, and I deal a lot with family law matters, child custody, divorce, relocation, guardianship issues, and so on. So that's what I basically do and what I know very well. Today's webinar, the title is How to Win Your Child Maintenance Case, in brackets, application, substitution, and discharge. Those are basically the three type of scenarios you will encounter in dealing with a maintenance matter. Applications meaning where you're applying for child maintenance. Substitution where you want to change the maintenance order, either have it reduced or increased. And discharge, whereby you want to have the maintenance order set aside. So I hope you follow where that is concerned. Okay, somebody commented, I'm muted. I think I unmuted myself now and you'll be able to see and hear me. Thank you for that. Great stuff. So if you can't hear me, please message me, but you should be able to hear me. I would not be able to hear you. So this webinar, the plan is to go on for basically 1 full hour, hopefully 55 minutes. And I would be able to deal with all 18 questions. I will be entertaining live questions as well, whereby you can type your question in Zoom and in Facebook Live, but Zoom will be given preference. But I try to deal with both of them at the sitting. And I see a comment, share screen is blurred, I can't read the text. Unfortunately, if I share the main platform screen onto that is what happens, but I'll read the questions out as I go along. Okay, so the other way you can partake in the specific webinar is, if you're part of the Zoom, to put up your hand and advise me you would like to pose a question, and I would unmute you and you can pose a live question. If you have any questions and you want to do that specific way, please put up your hand as soon as possible and we can deal with that. I'm seeing the participants. I'm just changing something here. Yeah, so that's fine. So if you want to ask a question, please send me a message or put up your hand in the Zoom interface and we can begin. I'll start with the first question. Let's get to that one quickly. The first person that partook in the Zoom, who registered in the Zoom webinar and posed a question, the question was as follows. What can the applicant do if the respondent in a maintenance application is hiding assets and or moving assets of his or her name, I think of his or her name, to avoid paying any or more maintenance for his or her children? Yeah, so what's basically the scenario deals with a situation where one party does not want to pay maintenance and is hiding assets, putting assets maybe in a trust, selling them or liquidating them, with the ultimate goal and plan that he or she will be ordered to pay less maintenance. Obviously, the foundation or the thinking behind it is that if I do not have any assets, if I have no money, clearly the court cannot make an order for me to pay a higher amount. The court will have to make an order based upon what I currently own or what I currently afford. But at present, I have a lot of assets and the court will make a higher amount. But if I get rid of some of those assets or hide it away, I will obviously pay a much lesser amount. My advice to you is, to the specific questioner, is that you need to know the law and how the law works. The law works as follows, that you will have to prove whatever allegations you are making. If you are saying the other party is hiding money away, then you need to prove that the party is hiding money away, and you need to also show to the court that that is the amount of money that he or she is hiding away, or the assets. If you cannot do that, the court will have to deal with the matter as it's before him or her, the magistrate, I mean. So my advice to you is to be creative, be smart about it, obtain the person's banking details, maybe you can pick up some information regarding that, do property search, ITC searches. That's very, could possibly be very useful, doing an ITC search, a credit search where the party might, for example, have applied for credit and so on. Bank statements are very useful, and just investigate. Pay someone to investigate a specific person. But at the end of the day, if you cannot prove that the person has any money or any assets or is hiding assets, maybe that is the case. Maybe he does not have any assets which has been hidden, or she. You'll have to prove it, and you'll have to make sure that you can present it to the court if the other party is denying it. I hope it answers question number 1. I'm seeing questions coming in on my right hand side in the Zoom, so I will deal with that as well. I will definitely deal with it. Let me just get to the full screen mode here. I'm not seeing any hands going up, so if you have any specific questions and like to pose something, you're welcome to do so. Put up your hand and I will deal with you accordingly. Okay, so everybody's microphones are muted. Let's deal with the second question. After 3 years, I have a trial date for March. Tomorrow, does the court look at what or how much money is being spent? That is grocery shopping at Woolies deemed necessary and the restaurant, etc.? They don't seem to. The court should. The court has to look at all information, all facts before it. The court needs to do that. And if one party is saying, I am unable to pay the amount of maintenance requested, but he or she purchased items at expensive stores. Let's say, for argument's sake, bread at Woolworths costs more money than ShopRite. I do not know. I'm not saying one. I'm not dealing with that consumer issues, but let's say that is the case. An argument can be made. The child requires maintenance, but you're spending lavishly. You're spending on items which cost much more money at a certain store and much less at another store. So you need to change the store you are purchasing food from. You need to spend less money on food, or spend less money on the specific item, and in doing so you will have much more money to spend on child maintenance. So the court does that, but it's for you to argue that point. That's very important. The court won't on its own just know that Woolworths costs more money, or Pick n Pay costs more, Pick n Pay costs less, or Woolworths costs less, depending upon where you're buying. You need to present that argument and present that case and work out it mathematically, and you should work it out. You should say, when the parent goes to shop A and purchases the necessary groceries, it comes to 1,000 rand. But if he or she goes to shop B, it costs 700 rand. That's how what you present to the court. Not only an allegation, but you come with a constructive argument to the court, which can sway the court in making a specific decision based upon what you have stated. I hope it answers question number 2's question. Let me get to at least question number 7, and then we can go to the live. But please put up your hand. I'm watching the screen. If you have any specific questions and I can bring you in, let me do so. After the father of my son decided not to see his child anymore, he did not pay maintenance as he used to. He just stopped paying, took my son off his medical aid, and is currently on my medical aid. So the father stopped seeing the child, and he decided to, I didn't know, maybe to spite the mommy, whatever the case may be, to stop paying child maintenance. Now the child is on the mother's medical aid and no longer the father's medical aid, because the father took the child off his medical aid. 2 scenarios, 2 questions I have. If there is a court order in place, he's committing a criminal offense, my advice to you is to go to the criminal court as soon as possible, or to the maintenance court, and they will decide criminal or civilly. If there's no court order in place, please go to the maintenance court as soon as possible, and they will make sure there's a maintenance order in place, and at the same time they can technically backdate the maintenance amount. So if the father stopped paying for the last year and the amount was maybe, for example, 1,000 a month, you should pay the 12,000 rand to you. I hope that answers that question. Question number 4. What if your kids are immigrating to Eurozone, maybe like to the UK and those countries, with her new husband and your kids? What options do I have for the potential burden of the extra costs associated with Euro cost for them, and I'm unemployed? Now, your obligation would be basically the same. Now the child is living in the United Kingdom, euros apply. So if you paid, let's say, 1,000 and maintenance in South Africa, I don't know what the euro is, but it's no longer 1,000 euros. It will be maybe a few hundred euros, or much less. So whatever the case may be, the court will have to consider that. And if there's no court order in place, there's no maintenance formalization of the maintenance an agreement, and you've always been paying the 1,000 rand per month, all that you have to do is continue to pay the 1,000 rand a month. Things might also change in the United Kingdom, where the parties are moving to. Maybe the cost of living is much less, based upon based upon how much the parents are earning. So the mother might be getting a better job, things may be different, or the cost of living might be much more, where they'll be coming home with less. If that is all that you can afford to pay, then you should just pay that. If you are unemployed, that's something else, then maybe you should pay less, but let the maintenance court assist you and advise you regarding that. I hope that answered that specific question. Question number 5. If there is constant non-compliance by the other party with both maintenance and parenting plan and constant threats, that what advice can you give in building evidence? So the person is not attending to the maintenance agreement, non-compliance with the maintenance order, not complying with the parenting plan, and constant threats. I don't know what the threats are, but my advice to you is, if somebody does not comply with a maintenance agreement, you need to follow the necessary procedures. You go to court, you lay a complaint. If there's a maintenance order in place, you sort that out as well. You have the person criminally charged, if that's what the maintenance court would advise you to do, or you have the person's property attached. With a parenting plan, it becomes a bit complicated. If the person does not want to have contact in terms of the parenting plan, you can't force someone, in my view, to love a child. That's unfortunate. You can't do that. But the person has to at least adhere to the parenting plan. If the person is not adhering to the parenting plan, if the parenting plan says specifically that he can collect the child at 5 o'clock and he comes at 6 o'clock and he should drop the child back at 7 o'clock, but you were waiting an hour, you shouldn't put your life on hold because the other person is being unreasonable. Or the contact should be on this weekend, but the person doesn't pitch and now the person wants to have contact the following weekend. You need to stick to the parenting plan. My advice to many parents, or most parents, when it comes to the issue regarding non-compliance with parenting plans, is for the party to see some professional person, a parenting counselor, etc., a co-parenting counselor that can assist the parties in resolving those specific issues. But if someone does not adhere to these type of agreements, clearly externally, when someone does not adhere to a parenting agreement, sometimes we require some type of external help. What are the underlying issues? Because the child needs to have contact with both parents. But if you're not complying with a maintenance agreement, sorry, I have no sympathy for that person. You need to go to court. I hope that answered that specific question. If there are any questions, people that want to phone into the Zoom call, please not unmute, please put up your hand. I'm looking at the screen and you can do so, and you can live question me. If I have dealt with a question not as you wanted me to do, because you have an additional question or I didn't read the question correctly, please call in and we can take it from there. So that sorts that out. Okay, I'm looking at the chat quickly. I need to keep an eye over there. There are some questions in the chat. Let me maybe deal with that quickly. Good advocate, what procedure has to be followed in order to have an annulment order made against the other parent? For example, a garnish order. Basically an order whereby the other party, someone else, should pay the maintenance on behalf of the other parent. Do you have to do an application to the maintenance court with a next affidavit, or do you have to ask a maintenance officer? So generally what happens is, when a maintenance order is granted, generally the court would make an attachment annulment order or a garnish order, will make such an order, but the parties usually come to an agreement, or the court can say, no man, this person will adhere to the agreement. The only basis you can have to make this application afterwards, let me admit some people in, sorry about that. Those who are joining, thank you for joining us. My apologies for letting you in a bit late. I was focusing on a different screen. Okay, so if someone is not adhering to a maintenance order, then obviously you'd want to approach the court. So there are specific forms that should be completed at the maintenance court when you lay a complaint. Therefore, my quick answer to you is, go to the maintenance court, mention to the maintenance court the other party is not adhering to the maintenance order. There are a few things they can do, attach property, garnish, and so on. Do that, and they will obviously be able to assist you. So that's the questionnaire, the live questionnaire on Zoom that posed that specific question. If I never answer the question correctly, please advise. I have another question. If the kids were living at Holy's bred life up until the divorce, does the court not look at the father maintaining the children's similar standard of living? Yes, the courts try to have the children live a similar standard of living as they have while the parents are married. But the challenge we have is, and the difficulty that we are faced with is, that while the parties are living together, there is generally one car, one house, one bill, one rental bill, one bond bill, one car for the family. They use the same electricity in the living room. You follow where I'm going to? So the expenses are less compared to being two households. Once the parties are now divorced, they're separated, the expenses becomes more because the father will have to now rent property as well. Now that becomes a challenge, or he has to purchase property as well. First they only had one bond, now they have to have two bonds. The expenses becomes much more. So you follow where I'm going to where that is concerned. So it's difficult to say that the standard of living will be the same. Generally it will not be. Generally the standard of living will go down, will become less, especially because of the rental expenditure. But if generally the courts try to have the standard of living remain the same, so if the parties are wealthy and they can afford it and there won't be a big problem regarding the standard of living, the court will make such an order. Let me have a look at the Facebook Live. I see some questions on the Facebook Live as well, and I shall deal with two of them quickly, and then I'll go back to the questions that the people posed before the time. Thank you for that. So the first question I have is, how long can a maintenance case take to be resolved or settled if all the relevant documentation from both parties have been handed into the investigation for the investigating officer? Quick. It all depends on the magistrate. If the magistrate is available within 3 months' time, within 2 months' time, sometimes they're available very quick. They say my diary is available in a month's time. You're welcome to attend to my main. She gives you the date in 2 months' time or in a month's time. That is a date the matter will be finalized. But there's another challenge, another potential challenge in the sense of how many witnesses you have, how long will your case actually drag in the Pacific Court. So for argument's sake, if I am a long-breathed lawyer and I feel that I want to cross-examine the father for 6 hours and deal with every single point, the court might have to give me 2 days to do that. And I want to cross-examine his employer, his mother, his wife, if the court allows me to call them as witnesses. And at the same time, I would like to call my witness and her new husband and all those specific things. So the court might have to postpone this matter longer, in the sense of the court deals with today, we relook our diaries, we postpone it for another 2 months to finalize the matter, to call the other parties or to call another witness. So that can take some time. But as you mentioned early on, all the documentation are there. It's all about the magistrate's diary and the lawyer's diary, because sometimes the court is available but the lawyers are not available. So that's a Facebook Live question. I got another question. Can you suggest a person or company we can contact to do a credit check on the other party, and should we leave it for the maintenance investigator? There are many people that can do it. Felicity Ann Guest, you can just Google her. She's connected to our lawyer also. She will be able to assist you regarding something like that. A credit record is obviously private, so some companies can obtain this documentation. I don't know how they do that, but you can speak to Ms. Guest and she can maybe advise you of places that can assist or resources that can be used legitimately to assist you in obtaining information. Alternatively, the maintenance officer can do it as well. The challenge with the maintenance officer is you in their court, I believe, in a more proactive way of dealing with these matters, whereby you obtain information, you present information, and the matter gets resolved much quicker. Okay, we have another Facebook Live question. The last one for now. You're welcome to pose as much as you want to. Dad pays X amount of maintenance for his 7-year-old son. This amount was determined by the lawyer of his ex-wife and the expenses of the child she gave. She says she buys 1,000 in clothing for him every month, but she refuses to give proof. Can one ask for proof since Daddy is contributing towards the 1,000 worth of clothing? The stalking makes you thirsty. Okay, so long story short, I do not know if there's a court order in place. If there's a court order in place, then you must just adhere to the court order. Asking for proof, why would you want to do that? That might just cause additional arguments, additional issues. Yes, you'd like to have proof, but it means that the party will have to engage with each other all the time, because now the mother buys the clothing, now she must give the father proof. That would have been resolved in the maintenance court. If there is no maintenance order in place, maybe the father can say, Mother, I do not believe you are spending so much money on the children. I'm only paying you so much because I think that's what you are spending, and let's resolve this matter at the maintenance court. I do not know, maybe that is a way of dealing with the matter. Or the simplest way would be just to pay the money because the child is using clothing. And at the same time, it does not mean that every month you spend 1,000. Specifically, this month you might spend 200 rand, but next month you spend 1,800 rand because now the child requires winter clothing, shoes, and a jacket. My thing is, you can't force somebody to provide proof unless a court orders that person to do so. And sometimes having this type of communication all the time just causes more problems than less. Okay, those are the questions on Facebook Live. Thank you for that. On the Zoom, I'm seeing additional questions. Let me deal with that quickly, and then I will have to get back to the question that were posed before the time. Okay, before approaching the court, baby daddy didn't pay maintenance for 8 months. But when I approached the court, they only allowed him to start paying after the maintenance order was issued. Apparently, for the outstanding money, I should pursue a civil court. How do I do that? I do not think the court should have done that because the court can make an order in terms of the Maintenance Act for him to pay maintenance in the past. Since the child was born, you can pay for that as well. You can pay for the birthing as well. That's also possible in terms of the Maintenance Act. But if that is the order that they have made and we need to move forward, my advice to you is either, depending upon the amount of money, if it's a huge amount of money, maybe get an attorney on board. If it's a small amount of money, then maybe do it yourself. But the bottom line is you need to summons him to court, send a letter of demand, draft a summons outlining exactly how much he owes you. Your first allegation might be he's the father, you are the mother, a child was born, you did not support the child, the monthly expense of the child was so much money. You've contributed your fair share, but he has to contribute X amount of money, and the amount owing is now so much money, and he should pay it. So that's the long and the short of that. I would actually advise you maybe to see an attorney to assist you with such a claim. Maybe send a little demand and maybe he pays. Okay, and another question on the Zoom, a live question on the Zoom. I earn more than my ex-husband, and he still expects me to do more even after divorce. Divorce put him at a primary residency because I was the one leaving the marriage home and opted to get him out of the property I had before marriage, which he got his name on. Sorry about that, due to COP. So basically, the long and the short of the matter is that the parties were married. In the divorce settlement was that the mother will keep the house, sorry, the father will keep the house and the mother moved out. Now the father is just expecting the mother to pay much more maintenance to the father. So I do not know what the specific question here is, but I would presume that we're dealing with a situation here whereby the father now wants much more money from the mother. At the end of the day, the court will have to pay. The court will make an order that the party should pay according to their means. So if the mother is earning much more than the father, and the father is a primary caregiver, an argument can be made, and it would be made that she should contribute much more towards the expenditure of the kids. If the house is fully paid up and the father is enjoying the home, then obviously he's not incurring any rental expenditure, and that is something which obviously will have to be considered. So his contribution towards the expenditure of the children's living conditions is in providing the children with a home. But the bottom line is, if you are earning more than the other party, you will generally pay more than the parent who is caring for the minor children, or the other parent. Okay, additional question. What can be done if the maintenance investigator in another province is not responding? The father hasn't been served since October and I keep getting new dates. These are the problems with the incompetency of the maintenance courts. Not all of them, but some of them are. My best advice to you is to complain. Go higher up the ladder. Complain to the media. Complain to the provincial minister of justice in that specific province and make a noise. And by doing so, they will definitely do their job. Last question on the Zoom, and I'm hoping to see some call-ins. Our daughter doesn't want to be with him Monday to Friday, so I find myself taking his school, and he doesn't want to contribute to fuel. Can he do that? So we have a problem here is the daughter shouldn't decide, a minor shouldn't decide what he or she wants to do. Parents decide whether, if a child should be with a mom or dad. For argument's sake, let's say the child should be with a mom Monday to school. Now the child said, no, I want to stay by dad a week. I don't want to go back to mom. How can the child decide that? It's the parents that decide what's best for the kids. So the child should basically go to the dad, but she's not going there. And now the mother is now spending all this money concerning fuel. If that is the case, you can go to the maintenance court and ask the maintenance court for the father to pay more maintenance, because now you are paying towards the fuel of the minor child. But it's a messy situation because the child should be with the dad and the dad should be taking the child to the school. So I honestly think the best way to resolve this matter is for the party to sit on the same table together with a professional person, with a mediator, to resolve this issue. Because the problem we have here is the child should be with the dad. Okay, I'm going back to the questions that the parties pose when they're registering. And from there we can go back to the Zoom questions and to the Facebook Live questions. Okay, question number 6. That's the next question. The father can't pay adequate child maintenance. His father has passed away and his mother is remarried, but does not work or earn an income. Can maintenance be claimed by her husband? Meaning, can maintenance be claimed by the step grandfather? No, it cannot. It cannot be claimed from him. He has no legal obligation to maintain his step grandchildren. If the court decides, this is a highly technical angle to take it from, but it can work. If the court says the father can't afford, and we have to go to the grandparents, but the grandfather passed away, but the grandmother remarried in community of property, and she automatically became wealthy. It's possible that the joint estate, because the mother owns part of the grandmother owns part of the joint estate, can be responsible for the maintenance. But it's a highly technical argument, and I would advise you to make use of a lawyer if you're taking that approach. Okay, question number 7. I want to ask about a father that is not working a 9-to-5 job but still can make money for himself. If you're not working 9-to-5, you're self-employed, if you own a small operation, an informal operation, you still have a legal obligation to maintain your kids. Not because people that are self-employed, I'm self-employed, basically all lawyers are self-employed. You still have a legal obligation to pay maintenance, even if you are working, if you're not working 9-to-5. Let us get to question number 8. Regarding child maintenance, can a child be emancipated from a parent in South Africa? What are the laws regarding emancipation of a minor child in SA, specifically relating to child maintenance, maintaining the minor child? Emancipation is not the topic of our discussion. I think this is more of an academic question. I've out of my own put in the definition of emancipation, or maybe give you an understanding of it. Emancipation is when the parent or guardian agrees, either expressly or tacitly, that he can act as an economically independent person. There should be an emancipation. Okay, so basically the child lives on his own, he's 17 years old or under, he's not in a major, he's not 18 years old, and he's emancipated. The parents say, no, my child, do whatever you want to do, live on your own, do whatever the case may be. Such a child becomes emancipated, he's economically sound, he can look after himself. If that is the case, there's no legal obligation for the parents to maintain that specific child, because the child is self-supporting, and that's why you emancipated the child. I hope that answers your specific question to that specific commenter. Question number 9. My ex-husband pays maintenance in accordance with a High Court divorce order from 2012. He is unemployed for a year now due to COVID, but continued to pay until yesterday, when he only paid half. He has a legal obligation to comply with the 2012 maintenance High Court order. You are entitled to approach the maintenance court and lay a complaint, but before you do that, find out from him why is he paying half. Now, there might be a valid reason for that, and maybe he can catch up with it later in the year. Maybe all his pension money is up. I do not know. Find out by him what is his argument. If it's a reasonable argument, have something in writing, come to some type of agreement. If it's not, go to the maintenance court and lay a complaint. Okay, that's question number 10. Let me quickly see if anybody wants to come into the Zoom. We have some questions on the Zoom. That's great. Yes, I see somebody put up their hand. Wonderful. I will unmute the specific person if you are still there and you can pose a question live. Let me do that. Just 1 second. There you go, ahead. The person that put up their hand, they're welcome to pose a question. You're welcome to chat.
Hi, speaking to Courtney. I actually posted my question in the chat box, but I thought it might be easier for me to ask you in person. So I was at court yesterday. The matter was postponed, and my ex basically requested legal representation. So I wanted to first ask, it is more of a two-part question. The first question I'd like to ask is, if he shows up on the next date without a lawyer, will it be postponed again for this? Like, can it be postponed again for the same reason? The reason I ask this is because I fear that he would try and use this as a stall tactic to kind of draw this out longer than it should be. So I wanted to know, if he rocks up on that day and says, no, he doesn't have legal counsel, he wants legal counsel again, can he keep doing that over and over just to stall the process? So that was question number one. And then the other thing that I wanted to mention is, so my child's expenses comes up to about, and I'm just talking about his schooling, uniform, medical aid and stuff like that. I'm not even talking about like the day-to-day. His expenses come up to in excess of 5,000 Rand. And when I approached the court, I obviously gave them a settlement amount, which I am comfortable with him contributing. And all I asked for, it was an amount of about 1,400. But I even went as low as saying 1,000 Rand towards school fees. And he can even pay directly to the school, you know, that type of thing for the contribution side. When we posed the settlement agreement to him, he said that he can't afford a cent. He can't afford a cent, so therefore we just need to, like, basically we can't resolve it because he can't afford anything. What happens in a case like this, where would the court turn around and say, you know what, he can't afford it, sorry, there's nothing we can do?
No, that's fine. I will answer those questions. If I didn't answer it correctly, there's later on you can come back on again and I will continue again from regarding that. So let me just answer the question quickly.
Perfect.
Okay. So the long and the short of it, firstly, the court magistrate has a legal obligation, obviously, to ensure that maintenance matters are expeditiously done. So if the father comes to court and he says, I do not have a lawyer, unless you can show that the lawyer was in a right of accident, or something legitimately happened which will justify the matter being postponed for another lawyer, and if the court doesn't do that, it won't be in the interest of justice, then the court will obviously make such a ruling and the court might postpone the matter again. But if the court and the magistrates are smart, they're witty, if they can see this is a delaying tactic on the part of the father side, then they should proceed with this matter, because it's not a requirement for the father to be legally represented. It's not a requirement. It's a right which he has, and a right which he cannot abuse. So you must just have an argument in place and explain to the court that this is prejudicing you, it's affecting the maintenance of the minor children, and this is now the second time that he's requesting a postponement for his lawyer, and his lawyer isn't here. In the interest of justice, the matter must proceed. His lawyer can always pitch up here the next time whenever the matter is now ready to go, but the matter cannot stop. The matter must go ahead. And if it means that the father presents evidence without the lawyer, that is it. He had his opportunity. But it's up to you to convince the court, because if the court is convinced that the father is playing games, the court will not give into those specific games. But at the same time, if the court is convinced he's not playing games, then the court will grant the remand. Regarding your second question, the end of the day, the court will make a decision based upon the evidence before it. And in order for the court to make a proper decision, the court will have to run trial. have to run a maintenance inquiry, a formal inquiry. So if the father is saying, I cannot afford, whatever the case may be, he's welcome to say so. He can say that. And he will obviously have to prove it. But the onus and the burden will be upon you to show the court that he can afford, that he is able to afford. But even if the court believes that he is hiding assets or he is not being candid to the court, what can the court do? Well, the court guess he's hiding 10,000 rand away or 50,000 rand away or 1,000 rand away. So when the court makes its maintenance order, the court will have to base it upon actual figures before it, not guesses, not assumptions. And this is how the court will have to deal with the matter. Therefore, I stress on all my clients or anyone who consults with me and who's dealing with the matter on their own, or sometimes attorneys come to me and they consult with me and ask me for advice. I advise them, you need to ensure that you present a proper case, and you should not be dependent upon the other side to assist you in your case. If they do in a way assist you by providing you with information, wonderful. But if they do not do that, it's still upon you to ensure that a proper case has been presented. I hope that answers your question, and you're welcome to, put up your hand a bit later, or then I'll give you another opportunity to respond to that, and I will respond to that again. So we'll try to finish as much questions as possible for the people that registered before the time, and then we can deal with it more interactively as well. Question number 10. The Rule 43 order was obtained by default and X applied for decision and successfully had it cancelled 18 months later. Judge gave option to a reapply. My child is not in school now and we are struggling. So a Rule 43 order is a procedure that gets followed in the High Court where the parties are, there's a pending divorce, or one of the parties intends to divorce, or a pending matrimonial dispute. So I would presume the parties here there's a pending divorce taking place. But the problem is the Rule 43 order that was granted some time ago has been cancelled, so there is no maintenance order in place, but now the child is no longer in school and the parties are struggling. My advice to you is to apply back to court for more maintenance, or maintenance pending later, or maintenance pending the finalization of this matrimonial dispute. Alternatively, you can approach a maintenance court as well. I'm just concerned because it's 18 months and the divorce shouldn't take so long. The sooner these matters can be resolved with a maintenance order in place, the better for everyone. Okay, let's move to question number 11. If the father of my child is unemployed, can I go to the maintenance court to open a case against him because he did nothing? I'm struggling alone and am student and I don't have his ID number. I need help, please. Okay, I'm just reading verbatim, which I copy and paste these questions. If he's unemployed and he cannot find a job, there's his parents. If he's unemployed and he can find a job, he needs to go work. Either, with respect, he needs to work as a cleaner. I'm not really calling any jobs. As a packer, I don't know, whatever the case may be, something that is able to earn money. You need to sell goods, sell bread, whatever the case may be. So that is not an excuse not to pay child maintenance because I'm unemployed. It is an excuse, of course. I'm unemployed, I'm trying very hard. I'm doing whatever I can do. I've sold my cell phone, I sold my clothing, I sold everything I have in order to maintain the minor child, but I still do not have any money. That is a reasonable excuse. How can someone have a cell phone but the child is hungry? Question number 12. What must I do if I can't afford the maintenance anymore and I am in arrears with maintenance? My son turns 18 in August and I was told he could bring his own application. If you can't afford to pay the maintenance, you need to go to the maintenance court and apply for either a substitution, less maintenance, or a discharge. The maintenance order should be set aside. The court will look at all factors and the court will decide what is best for the minor child involved. I hope that answered that specific question. And yes, of course, if the child is 18 years old, he can apply for maintenance for himself or an increase, whatever the case may be. Question number 13. What does one do if the father claims he cannot pay a cent for the child? They have requested his financials, but what happens? Does everything fall on the mother for the rest of the child's life? No. If he says he can't afford, the court must be convinced that he can't afford. He needs to present evidence, information to the court saying, I can't afford, but that's not indefinite. He must come back to the maintenance court 3-4 months later. And then he must explain to the court, I've applied here, I've applied there. I've applied to Woolworths, I've applied to Pick and Pay, I've applied to ShopRite. Those are the the businesses we mentioned earlier on, and we'll continue mentioning them again. So you need to show to the court he done that. I think they give you job documentation, job forms where you show, you apply. How is he eating? How is he surviving? He's still alive. I'm sure he has a cell phone. He must sell this. He must sell the cell phone. If it's a nice cell phone, sell it. Buy a cheaper one that has the basics, WhatsApp and SMS and a phone on it. You need to sell his clothing. He should have decent clothing, but if he has any expensive clothing, a leather jacket, a nice suit, he needs to sell it in order for the minor child to have maintenance. So therefore, being unemployed is not the reason enough not to pay child maintenance. You can wash cars, charge 10 rand to wash a car, and use that money to pay child maintenance. Okay, question number 4. Which documents are needed for maintenance? Basically, you go to the maintenance court. They have an application form. They may require your ID document, the birth certificate of the kids, whatever documentation you have regarding the father, maybe his ID number. Yes, of course, his ID number. But if you do not have it, they can investigate that. Of course, they need his address, because how will they serve him, or his work address, whatever the case may be. My advice to anyone is, if you do not have all the information or any information, and there is a father out there, still approach a maintenance court. They have maintenance investigators that should assist you. Okay, question number 15. We're getting close to the end and we can engage a bit more. My son was maintained by his father who is alive. Sorry, it was late. How could I see alive? It was late. So he passed away. His elder sister said he will only get his share of the money when he is 18 years old. He turned 18 last year. We lost contact. Where do I go? So I presume he inherited money. They placed the money maybe in the guardianship fund with the master's office. I'm presuming so. The best advice I have to you is, wherever the father passed away, get some of his details. Go to the master's office where he passed away. If it's in the Western Cape, you come to the master of the High Court here in Cape Town. It's like 50 meters from my office. Google my office. If it's in Durban, it will be the master's office in Durban, Johannesburg, and so on. And then you inquire from them on the specific estate, and they will be able to advise you where the money was sent or where it went to. So that is number 15. Let's see what other questions we have. We have no additional Facebook Live questions. That is in order. Let me have a look at the Zoom. Okay, we're back at the Zoom. Okay, the question early on, the lady that spoke live, I see your question, and I think I have resolved that specific question. Additional question goes as follows. Does your response to a minor child not being able to say with whom they feel comfortable being with mean that children, not toddlers, are still seen, not heard in South Africa, especially during the divorce transition, when the one parent still bashes the other, and now it results in the child not wanting to be with in the primary residence? So the question basically deals with the issue of, when do you listen to the child, the voice of the child. Now the Children's Act specifically says, depending upon the maturity of the child, the court will have to give consideration to that. So that is there. We listen to the child, but we do not only listen to the child. We do not take what the child wants and give the child what the child wants. So for tomorrow, the child says, no, I want to stay with dad because all my cousins are living around the corner. And then tomorrow, the child has an argument with dad. No, I want tomorrow live with a mom. Then all custody disputes shouldn't be dealt with mom and dad. It should only deal with the minor child. So we listen to what the child wants and why they want what they want. It's very important. Why do you want to stay with mom? Why do you want to stay with dad? I want to stay with dad because on weekends it's McDonald's, it's the good life, family comes over, there's no homework, there's no curfew, there's nothing. Life is great there, dad. I do not want to live with mom because mom does homework, mom washes me on time, mom says I can't watch TV, mom says I must do the following chores. Therefore, I do not want to live with mom, I want to live with dad. That's what the kids will be saying. So we listen to them. Or sometimes the child will say something very responsible and says, I want to live with my dad I no longer want to learn to live with mom because I'm now in grade 9. And if I live with mom, there are stepchildren there, and I love them to bits, but I cannot study. And my school is closer to dad. So those are reasonable reasons. We listen to that, and then we listen to mom and dad again. We listen to the parents again. What do they specifically want? What are the issues involved over here? Because those are the serious things. What's workable? Does it make sense for the child to live with dad, but dad works whole day, or the mother works whole day? So those are the things. So we listen to the mom, we listen to the kids based upon the maturity, but we give it due consideration. But it's only one of the factors we look at. The same way we don't only listen to the mom, we don't only listen to the dad. We listen to everyone. Okay, I think that question has been dealt with there. I see no one's hands up. If you want to put up your hand, you are welcome to put up your hand, and I'll zoom you in and we can chat a bit. I'm trying to end this webinar in the next, just before 2 o'clock. It seems to me if I go over an hour, it becomes a bit too long. Okay. 3 more questions. Let's deal with it. Question number 16. How to pursue a civil case when a maintenance order is already issued? How do I quantify the cost associated if he didn't pay for 8 months before the maintenance order was issued? You will have to work that out. The child wakes up in the morning, the child has breakfast. The child has lunch, the child has supper. The grocery bill for the month comes to 300 Rand. I'm using simple figures here, so it costs 30 Rand a day. You unpack it, you work it out. The child costs so much money per month for food. The rental for the specific accommodation or the bond, whatever the case may be, costs so much money. There are 4 people living in this house. The child is one of them. The child uses as much facilities and amenities as anybody else in this house. Had I not had a child, I would have had a smaller property, which will cost less. Therefore, the other party should pay, or at least I should allocate this amount for the child's living expenditure. Then we move on. Educational expenditure, clothing, etc. Then you unpack it and you work out, okay, the child costs so much money per month on average. Okay, I buy clothing every second month, but I spend 1,000 Rand per month. Therefore, 500 Rand per month. And then that's how I quantify the maintenance for the child. Going backwards, 16 months. And also look at your bank statements, look at your receipts, whatever you have. There might have been certain stuff, entertainment, toiletries. You can work it out. I hope that assists you a bit. Need information about starting the process of applying for maintenance. I'm even questioning whether or not to go through with it. My best advice to you is go to the maintenance court as soon as possible, lay a complaint, but before you do that, make sure that you have your outline of your income and your expenditure for the minor child. Unpack it nicely. On our website, ourlawyer.co.za, there's a lot of information on how to apply for child maintenance, the process, etc. Just Google how to apply for child maintenance, our lawyer in Google. Automatically you'll find those specific resources. And the last question. In split care of 60-40 in school term and 50-50 holiday care, are direct and indirect costs in both homes considered? That's the first question. So if I unpack this question, meaning that during the school term, the child is most probably with a mom for 4 days and with dad for 3 days. Yeah, if I worked it out correctly, or vice versa. But during the holiday time, it's 50-50. They spend half the holidays with either parents. There are indirect costs and direct expenditure. All these things should be considered, but it all depends upon how do you present it to the court. That is why you need to work on a spreadsheet, you need to work with documentation, and you need to present a case and tell the court, these are the expenditures we incur during the school term, and these are expenditure which we incur during the holiday term, direct, indirect, whatever the case may be, and this is the amount I come with. This is my case, this is my presentation. That's how you do it. And the court will have to consider all of that. The second question for question number 18 would be as follows. If primary parent loses a job, do they need to relook living costs? Yes, they have to relook everything now, because his or her contribution will be less, or maybe zero, I do not know. So we have to relook everything. And if one parent cannot afford to pay child maintenance, then maybe the standard of living of the kids must come down. So if there's a change in circumstances, or if the primary caregiver now earns 20 times the salary, 20 times, I'm using a very extravagant example, then obviously we have to look at everything again. Because the contribution of the other parent will have to be less. Might have to be 20 times less as well. I do not know. So everything has to be looked at when deciding on a fair amount of child maintenance. I hope that answers your question. If anybody has a specific question, if you want to put up your hand, please do so now. I'll be going to the Facebook questions, and if there aren't any questions, I think we've done extremely well today. We had a full house basically. Many people signed in for the Zoom webinar. We do not expect you to be here live. Some people are working, some people are not able to. They're collecting the kids, whatever the case may be. But at the same time, you will immediately get an email tomorrow sometime at least. We have to upload this video onto YouTube, and you will be able to get this video. So for our next webinar next week, you'll see the details coming up soon. Tomorrow we will post that details. It will be on child custody, something to do with that. If you cannot make it to the webinar, still register, so you're part of that system, and we'll be able to provide you with the necessary details afterwards. Or you can pose a question and watch the webinar later on. I will deal with that. So on the Zoom, I see nobody's hands up. Okay, I see somebody's hands up. Let me go there. Let me unmute you. And you're welcome to speak.
Mohammed, thank you for this. I've put up a few questions in the Zoom chat. If you can have a look at those, please. Thank you.
Sorry, I'm just moving screens. There's the Zoom screen, there's a Facebook Live screen, and so on. Let me get to the chat. Okay, so let me see now. I see the questions. Okay, under what grounds can the court ask the grandparents to contribute towards maintenance? Much of my kids' lifestyle came from. Much of my kids' lifestyle came from the father's family business, which the grandparents run and the father works on. Is that your first question? Yes, I would presume so. So basically, in my view on the matter is, you can only go against grandparents if the specific parent, the father, can no longer afford to pay child maintenance or afford to pay adequate child maintenance. That is a basis upon where you can climb the ladder going further up. Otherwise, the parents must sort out this issue. The grandparents already had to maintain their specific children. So let me get to that question again here. I'm just moving from here. So if the grandparents was part and parcel of the minor children's lifestyle, and they were the reason why the children were accustomed to a certain lifestyle, which the father could not afford to do, but the grandparents were involved and they made it happen, then that is a basis upon which to approach the grandparents. If the business is no longer successful and they can no longer afford it, then unfortunately your case becomes a bit weaker where that is concerned. Okay, I have another question. How does reduction in salary due to COVID-19 affect matters? Does the court not look at the salary prior to COVID? Because the salary will soon go back to normal post-COVID. The court will have to deal with the matter as at present, not on how the court presumes it will be in the future. If the court makes an order based upon present, that the father should pay less because of COVID-19, or the mother should pay less, and 6 months later or the next month the father gets a better job and he earns more money, then you can approach a maintenance court again for an increase, but the increase will be based upon how much a father is actually earning at a specific time. He might be earning the same, or he might be earning more. But where I'm going to with this is, the court will have to make a decision based upon the current circumstances, because before COVID-19 he earned 1,000 per month. After COVID-19, when he gets a job, he might earn 500 or he might earn 10,000 per month. Okay, so here's the last question, but you're welcome to pose any further questions, but we have to end it in the next few minutes time. I have my first date of maintenance court next week. He is bringing his attorney. Is it necessary for us to bring our attorney on the visit as well? I strongly advise you, if you can afford to get an attorney, to bring an attorney on board, because the attorney will be able to engage with the other side ask relevant questions, elicit relevant information. Where my strategy generally is in maintenance matters or any court matter is I like to listen. I don't like talking so much, because when I listen, I receive data, I analyze matters, and I'm in a better position to advise and assist you. I talk when I have to speak, of course, if the person asks me a question, if I think it's necessary, but I'm not there to be argumentative and argue unnecessarily if it will take me nowhere and limit the rapport I have with the other party. So if you have a lawyer, it might be a very good idea, because then the lawyers can speak and try to resolve this matter, especially because there's a lawyer on the other side. So I would advise you to come with an attorney. Okay. A Zoom question. Hi, advocate. A. Nice to be here. Thank you for the informative session. You are welcome. A short question. What about the situation where a child is estranged through parental alienation, practiced by one parent, and the child has not been seen for years, still paying contribution towards the child, but parent is now feeling abused? What can you do to stop or change the contribution? So parental alienation is a serious issue, but contact rights has nothing to do with maintenance rights. It's possible for a parent to have no contact with the child but still contribute towards the maintenance of the child. So my advice to you is, number one, fight for your rights as a parent to have contact with the child. And regarding the maintenance, if you see there's a change in circumstances, either the other parent is earning much more money or you earning much less money, on that basis you approach a court for a change of contribution, but not because of parental alienation per se. Okay, we have another question. I am really struggling with my internet connection. I am the one that posed a question about starting the maintenance process and doubting if I should go ahead with it. That's fine. When you address this question, my internet was down and I completely missed your response. Could you please have a response again, or email that specific address? Okay, so my response early on, it was mentioned. So what I'll do, I'll tell you what will happen is, regarding that, you will get a link on this video tomorrow, and you can watch a video again and you will be able to get the answer from there. So that's fine. We'll try to upload the link later on today. Alternatively, what will happen is we'll get a WhatsApp message with the link, so you can watch it later on today. So that was quite late on in the video, and you'll be able to get the specific answer to that specific question. Last question, pro rata question. Maintenance payment is based on this, but adult expenses, which a child portion is taken from if living with a new partner, is 50-50. Example, parents' house earns 20,000, yet they earn 10,000. But rent is calculated 50-50, and child portion claimed is a third of that. Does this pose living within means? Question. I do not understand the question so well. Do me a favor, and I will do this for the specific registrant. Rephrase the question, email it to the same address that we emailed you regarding all these specific notifications for this webinar. Pose it to me a bit differently, and I will personally respond to that. I think that is fine. I hope that assists you, and you're welcome to do that, and I will respond to it as soon as I get the email from you. Ladies and gentlemen, I told myself I'm ending this webinar just before 2 o'clock, and I think that is what I have to do today. It was a very informative webinar. We had 18 questions. We had many questions on the Facebook Live. We had many questions on the Zoom platform. And I think on child maintenance for the next one I'm having, I'll have it for an hour and a half. I think an hour is a bit too little for these specific webinars. Thank you very much for joining this webinar and partaking in it, and for registering for it, and for posing your questions. And those on Facebook Live, thank you very much for your time. And I hope you have a wonderful day, and stay safe, and looking forward to seeing you on our next live webinar. Thank you very much.